Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Hey, just a quick note. Today is April 22nd, 2024, and I am headed down to Dothan to have some work done on my left eye. But I'm not going to be able to do a fresh one today, and probably not going to be able to get one out for Tuesday. But if I can, I will try. Just wanted to let you know that up front. For the past few years, filing a Title VII case, and a discrimination case under Title VII, Civil Rights Act kinds of cases, has been a little bit like playing a slot machine for attorneys because you can never tell when you're going to get a payoff. The fact is that these cases end 90% of the time on either a motion to dismiss or a summary judgment. As a result of that, many attorneys are skittish about taking on an employment-related claim of any kind, but especially under the Federal Civil Rights Act, where they might have to litigate in federal court. But at least in my experience, they are very difficult to get through the door. Until now. The Supreme Court has just issued an opinion that I think is a game changer in that regard, and I want to talk about that today. The case is Jatonya Clayborn Muldrow versus the City of St. Louis, Missouri. Let's take a look at that now. So Justice Kagan delivered the opinion of the court. It says, Sergeant Jatonya Clayborn Muldrow maintains that her employer, the St. Louis Police Department, transferred her from one job to another because she is a woman. She sued under Title VII, alleging that she had suffered sex discrimination with respect to the terms or conditions of her employment. The courts below rejected the claim on the ground that the transfer did not cause Muldrow a significant employment disadvantage. Other courts have used similar standards in addressing Title VII suits arising from job transfers. Today, we disapprove that approach. Although an employee must show some harm from a forced transfer to prevail in a Title VII suit, she need not show that the injury satisfies a significance test. Title VII's text nowhere establishes that high bar. Now, what's notable about this case is that it is a unanimous 9-0 opinion to a certain extent. There are some concurrences, and some of those concurrences offer up explanations and indicate that the court is not 100% on board with all of the law in the case. However, they do appear to be on board with the result in the case. I think it's important to recognize that while they're articulating a new rule of law here, it isn't like it is set in stone like Excalibur. So, from 2008 to 2017, so 9 years, Sergeant Muldrow worked as a plainclothes officer in the police department's intelligence division. During her tenure there, she investigated public corruption cases, oversaw the gang unit, served as the head of the gun crimes unit, and by virtue of her division position, Muldrow was also deputized as a task force officer with the FBI, a status granting her, among other things, FBI credentials, an unmarked take-home vehicle, and the authority to pursue investigations outside of St. Louis. In 2017, the outgoing commander of the Intelligence Division told her newly appointed successor that Muldrow was a workhorse. Still more, that if there was one sergeant he could count on in the division, it was Muldrow. But the new Intelligence Division commander, Captain Michael Deba, instead asked the department to transfer Muldrow out of the unit. Deba wanted to replace Muldrow, whom he sometimes called Mrs. rather than the customary sergeant, with a male police officer. That officer, Deba later testified, seemed a better fit for the division's very dangerous work. The department approved the transfer against Muldrow's wishes. It reassigned her to a uniformed job in the department's 5th District. While Muldrow's rank and pay remained the same in her new position, her responsibilities, perks, and schedule did not. Now, that is at the heart of this case. She didn't lose any money. The only things she lost were her perks. And the perks included a take-home car and FBI credentials and all of that. Her new duties include approving arrests, reviewing reports, handling other administrative matters, supervising patrol officers, all of that, which is what a patrol sergeant would routinely do. The fact that she was transferred out of an plainclothes division and into a uniformed division really put her in terms of a rotating schedule. It put her on the streets at various hours. You can see that as a fairly significant disruption in someone's life. So because of that, because she didn't lose any pay or any fringe benefits really, other than the car, the case went to the district court, and this is what the district court did. She basically told the district court that all of these changes, putting her in a uniform, rotating schedule, few weekends off, responsibilities limited to that of administrative work, she said those were changes in the terms and conditions of her employment and that they were made because of her sex. And the fact that it was because of her sex was pretty clear from the record that they made. The district court, viewing the matter differently, granted the city summary judgment. Under circuit precedent, the court explained Muldrow needed to show that her transfer effected a significant change in working conditions, producing material employment disadvantages. And Muldrow, the court held, could not meet that heightened standard. She experienced no change in salary or rank. Her loss of the networking opportunities available in intelligence was immaterial because she had not provided evidence that it had harmed her career prospects. Now, I have for a long time said that the Eighth Circuit is the place that plaintiffs' cases go to die. And I think that's a fairly accurate description. Here you can see them reading into the statute terms of significance which are nowhere in the statute. How do I know that? Because I have the statute. And this is the part of the statute that matters most. It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, didn't happen, terms, yes, conditions, yes, or privileges, yes, of employment, because of such individual's race, color, sex, or national origin. So there you have it. If you discriminate on the basis of sex with respect to the terms, conditions, or privileges of employment, then you're violating the law. Nowhere in there does it say it has to be a significant or reach some kind of significance hurdle with respect to the terms of or conditions of employment. Not surprisingly, the Court of Appeals for the Eighth Circuit affirmed. It agreed that Muldrow had to, but could not, show that the transfer caused a materially significant disadvantage. Again, those terms are nowhere in the statute. That's made up out of whole cloth by the court on the basis of public policy, essentially their desire not to see the statute be abused, which isn't their place. If the statute needs to be addressed or fixed or modified, that's the job of Congress. The Eighth Circuit emphasized the transfer did not result in a diminution to her title, salary, or benefits, but that's wrong because it did indeed affect her benefits. The court didn't address Muldrow's new schedule or her loss of car, apparently thinking those matters either forfeited or too slight to mention. We granted certiorari to resolve the circuit split over whether an employee challenging a transfer under Title VII must meet heightened thresholds of harm, be it dubbed significant, serious, or something similar. We now vacate the judgment below because the text of Title VII imposes no such requirement. And that's exactly what I said. This is a huge problem with courts of appeal generally, in that they think they have a better view of what the statute should say than what it does. And the law is that it is the province of the courts to articulate what the law is, not what the law should be. Again, that's why we have separation of powers. That's why we have three co-equal branches of government. And unfortunately, a lot of the circuit courts don't understand and confine themselves to their role that the Constitution has assigned to them. Title VII makes it unlawful for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. I find it interesting that it's written with sexist language, his compensation. It's a throwback to the 1960s when this statute was passed. That transfer, as both parties agree, implicated the terms and conditions of Muldrow's employment, changing nothing less than the what, where, and when of her police work. So the statutory language applicable to the case prohibits discriminating against an individual with respect to the terms or conditions of employment because of that individual's sex. The language requires Muldrow to show some transfer brought about some disadvantageous change in an employment term or condition. The words discriminate against, as we have explained, refer to differences in treatment that injure employees, or otherwise said, the statute targets practices that treat a person worse because of sex or some other protected trait. In the typical transfer case, the worst treatment must pertain to and be with respect to employment terms or conditions. So, as you can see, Judge Kagan is reading this statute textually. One of the things that I get a kick out of sometimes is that the Alito, Thomas, and Roberts branch of the court tend to be textualists. They tend to be original intent textualists. What does the text say? And yet, on something like this, they are much more likely to go beyond the mere text. Again, that relates in many cases to the result. But here, they are willing to tolerate the result. They just don't completely agree with the approach taken by Judge Kagan. Let's look at a couple of those concurrences now. Judge Thomas here is saying that essentially he doesn't read the opinion from the Eighth Circuit the same way that Judge Kagan does. He says, I don't read it to have necessarily imposed a heightened harm standard. Eighth Circuit defined an adverse employment action as a tangible change in working conditions that produces a material employment disadvantage. It further explained that minor changes in duties or working conditions, even unpalatable or unwelcome ones, which cause no materially significant disadvantage, do not rise to the level of an adverse employment action. In other words, a plaintiff must have suffered an actual disadvantage as compared to minor changes, more than a trifling harm. That standard aligns with the court's observation that a plaintiff must show some disadvantageous change in an employment term or condition. The court insists the Eighth Circuit must have demanded more given the weight of Muldrow's allegations. Specifically, the court underscores Muldrow's claims that the city moved her plainclothes job in a prestigious specialized division with her take-home car to a uniform job, but most of those allegations are forfeited or are attributable to a non-party, the FBI, because they controlled the car. Well, again, Justice Thomas is reading this, I think, with too fine of a felt-tip pen. Judge Kagan is using a highlighter, which I think is what the Congress actually intended. And I love Judge Thomas. I really do. But I think he's wrong here. Judge Alito concurs in the judgment. He said, I agree with the judgment, assuming without deciding that all the facts mentioned by the court are relevant and properly presented. I do not join the court's unhelpful opinion. For decades, dozens of lower court judges with a wealth of experience handling Title VII cases have held that not every unwanted employment experience affects an employee's terms or conditions of employment. So what we have here is a slippery slope argument. Essentially, he's saying, you're opening the floodgates to all these new claims. And indeed, they might very well be, but that is up to Congress to fix. You have to apply the language of the statute. You don't get to rewrite the statute in the form of an opinion. And every one of the conservatives would take that if this, all you have to do is look at Dobbs to see that that's exactly what they did there. They took a textualist approach and it served their preferred policy outcome. Here, their preferred policy outcome is not being served, and as a result, they would prefer a different approach. But that doesn't mean that Judge Kagan is wrong. Now, Justice Kavanaugh, bless his heart, takes a completely different approach. He says, I therefore agree with the straightforward opinion jointly authored by Judge Title and Judge Ginsburg for an en banc D.C. Circuit. See Chambers v. District of Columbia from 2022. As that court explained, even when a transfer does not change an employee's compensation, a transfer does change the employee's terms, conditions, or privileges of employment. Therefore, a transfer made on the basis of an employee's race, color, national origin, sex, religion violates Title VII. As I see it, the D.C. Circuit saw it, the issue here is not complicated. Suppose an employee says to an employee at the Columbus office, we're transferring you to Cincinnati because you're black, but your compensation will not change. Does that violate Title VII. Of course it does. To begin with, the employer has treated the employee differently because of race. To be sure, the fact that a transfer may not involve a change in compensation can affect the amount of damages, as Muldrow's attorney acknowledges. But a transfer changes the terms, conditions, or privileges of employment. Therefore, a discriminatory transfer violates the statute. All he had to say was he agreed with the opinion of Judge Kagan. He wants to really open the floodgates here, which I think would probably not be as good an idea. We'll have to see how Judge Kagan's some harm test lasts over time. So that's what I have for you today. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. And of course, if you have the opportunity today, go out and do something kind for someone. And think some good thoughts for me today as I go through eye surgery. Thanks again for watching. And catch me back here down at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.